So dear all, welcome to this panel on state engagement and disengagement. It's a unique panel, I think, because it's the first panel which starts ahead of time, 5 minutes. So first of all, I'd like to thank Klaus Rackwitz, Vivian Dietrich, and Eduardo Telodo, I think, who've really put together a fantastic program. And I have to say, this conference is really, I think, one of the highlights of the events celebrating the 20th anniversary of the Rome Statute. Obviously, we have the unenviable task of conducting a panel after the lunch break. But I hope that the theme would be contributive to keep all of you awake. The panel is a good transition between our last panel on complementarity and the panel which follows us, engaging with the future and the future questions relating to international criminal justice. So the opening panel reminded us, of course, that we are at a critical stage in history. We are at a stage where multilateralism as a whole is under attack, and where the ICC, of course, as an institution, faces particular challenges. But this panel might hopefully take the debate a step further, because it's time to really take stock of how the ICC worked as a treaty system. And if we look at the ICC as a treaty system, we see that the statute in itself has probably been, to some extent, a real story of success. I would say it's to some extent become the Bible of practitioners who work in the field, although those who were involved in Rome know that the statute also makes a number of compromises on certain provisions that might not necessarily reflect other treaty law and might not necessarily reflect customary law in all respects. But the institution in itself has faced critiques and challenges. And if we look at these critiques and challenges, I think it's again important to try to take a differentiated and a nuanced look on how these critiques have actually unfolded. We've seen some new forms of engagement with the ICC and with the statute. So the very fact, it's been alluded to, that we had self-referrals triggering the jurisdiction has been one of the unexpected developments of the statute over the past 2 decades. We've seen declarations accepting the jurisdiction of the court under Article 12.3, and now we've seen in the context of the situation of Venezuela, the first collective referral of states parties. And again, this very idea, this notion that you would have a collective multilateral referral, that again is something which marks, I think, a novelty to a certain extent in the international justice systems. At the same time, we've seen new forms of disengagement. We've seen the unsigning, if such a notion exists in public international law, of the Rome Statute of the US and Russia. And then we've seen, obviously, withdrawals from the statute, declarations filed by Burundi and the Philippines. And again, this notion that one would have a withdrawal from the statute is something which goes very much against the spirit that the Rome Statute is a universal instrument. Some have referred to contemporary times as backlash against international criminal courts and tribunals. And I think, again, if we put this into perspective, I think it's important to distinguish on the one hand between backlash in the sense of real challenges to the authority of the ICC, so really fundamental critiques. Some of them have been voiced by the African Union. And on the other hand, critiques which are inherent to any treaty system, that any multilateral treaty system would face. And these critiques, I think, again, a normal reflection of the exercise of jurisdictional functions. We've also seen, I think, if we look back, that some of the backlash against the court has actually then had spin-over effects. It has empowered civil society in specific contexts. Whenever you challenge ICC authority, you might now have civil society organizations starting to proceed with legal actions, trying to combat some of the moves which have been promoted by states. And then again, we have seen domestic courts also playing a critical role in the debate on how backlashes against the statute should be performed. South Africa overturned, the Supreme Court overturned the withdrawal referral. In the context of the Philippines, we've seen the other approach. We've seen that that courts have actually given into the instrument of withdrawal. One of the crucial questions is, of course, the role of non-states parties. And I think here again, for the future, it's very important to have a nuanced assessment. Non-states parties are not unitary actors. Even within non-states parties, there are different voices. The Ministry of Justice will have a different voice on engagement with the ICC than Foreign Affairs or Defense might have. We see that some voices within non-states parties might want to engage with the ICC as part of a legal and a juridical actor who might really use the terms of the statute to engage with the ICCs, and we have again others who would say, no, we portray engagement with the court as political discourse. So these are some of the very tensions in which we operate, and I hope that our panel would pave allow us to understand where some of the discontents that we are facing actually come from. Some perspectives, I think, might require critical scrutiny. If we look historically, the 20th century has been very much about portraying the International Criminal Court as kind of a global institution which is at the center of international criminal justice discourse. And I think now in the 21st century, we actually see a different picture. We see a much more pluralist picture. We see justice 4D, so we see national jurisdiction, we see international jurisdiction, we have hybrid courts, we have regional courts. So the whole conversation about justice has actually become much more sophisticated over the past decade. And I think that's, again, an important development, I think, to reflect on. In relation to non-states parties, I think there are a few deeper points to address as part of the discourse. The first is a question which pertains more generally to public international law. How international is international criminal law in the first place? So, and isn't international criminal law as such not still guided by a West-centric focus that might benefit from a more pluralist discussions on the very foundations of the concepts that we are operating on? A second, I think, fundamental question is how the ICC could actually engage more soundly and more powerfully with the relationship to non-states parties. How could the ICC actually adopt structures to listen to some of the arguments and to develop a kind of atmosphere of constructive dialogue on this? So we've seen the debate on complementarity, and there are, at the moment, from those states who have been exposed to ICC proceedings, certain critiques that they have had difficulty to keep up with the pace of ICC investigations and prosecutions. And they've really faced challenges. Even systems which have been wanting to promote domestic investigations and prosecutions have said that the clock in The Hague is ticking at a different speed than the clock that is ticking basically in the situation countries which are affected by these crimes. So that again, I think, is something which requires further critical scrutiny. Some, like Stephen Kay, have argued that there should be, for instance, a greater margin of appreciation that the ICC should adopt in relation to some of the situations under consideration. So we have a wonderful panel, I think, to engage with some of these discontents and critiques, and I hope that this panel would have a triple focus. On the one hand, to allow us to understand the past, to allow us to understand some of the objections to the current treaty system, then secondly, to diagnose the status quo, and thirdly, and most importantly, to allow us to identify some recommendations about how we could move forward. So, first of all, I'd like to give the floor to Professor Erika de Wet. She is Professor of International Constitutional Law in the Faculty of Law of the University of Pretoria, and she also has an honorary professorship here in Germany at the University of Bonn. I know that, Erika, we've given you an almost impossible task because you cannot present the view of the African Union and to represent an African perspective, but still the first question to you would be, according to your experience and your assessment, what are the factors which actually contributed to the current relationship between the AU and the ICC? How did the original enthusiasm of South Africa, and again, let us remind us, South Africa has been crucial to put the crime of apartheid actually into the ICC statute. How did this relationship develop over time?
Thank you, Carsten, for the introduction and for the organizers for allowing us to be in this historic event. Now, I'll give an overview of, in my view, some of the main factors that contributed to the degeneration of the relationship between African countries as a whole, and within that there is, of course, also a role for South Africa. But let us just also remember that there was, and still to some extent is, engagement between Africa and the ICC. It was characterized by the very constructive role of many African countries during the ICC negotiations, and Pakiso was also very much involved in that. Look, Senegal was an African state, was the first to ratify the ICC statute. We had the first review conference on the ICC statute in Uganda, and African countries still concerns the largest bloc of members, 33 since the withdrawal of Burundi. And they are still friends of the court, and even if it will sound at times that I'm not one, that is not the case. But I do think it's not only a time for celebration, it's a time for reflection. And the relationship between the International Criminal Court and Africa is in trouble. And as we know, that is where all the cases have been generated from so far. Now, the disengagement was characterized by different actions, well, personified by, as we know, the very harsh rhetoric from high-level state officials, from the AU itself, the mass withdrawal strategy that certain countries in the AU is trying to pursue, blatant non-cooperation now of at least 8 states in not arresting President Bashir during his visits, and then I mean member states who are under a duty to have extradited him. Very selective cooperations in the case of self-referrals, and we've also seen complete non-cooperation ultimately in the case in Kenya and also with Burundi before its withdrawal. Now, the disengagement is also facing a pushback. That's the good news. There are countries in the continent that still want to engage. Nigeria, for example, not in the least due to Boko Haram, is very engaged. We have active civil societies and so on. And there is a disenchantment about the African Union overstepping its mark under the influence of certain states and claim to speak, for everybody on the continent, when there are actually still states that support the ICC. Now, the disengagement, in my view, as an academic who is unelectable for higher office and therefore at liberty to speak my mind, there are various key stakeholders to blame, and various incidents and stakeholders, and this makes it very easy. We created a situation that made it very easy for the enemies of the International Criminal Court on the continent and beyond. There are big enemies beyond, the biggest ones are beyond the continent, to portray the ICC as a very biased Western hegemonic instrument. And ladies and gentlemen, I'm running out of arguments politically countering this. As a lawyer in class, I have a big mouth, but I am at my wit's end. I come up with every legal argument I can. It's not working anymore. There is an immense sensitivity on the African continent around new colonization, which is played into by various powers and has been very much abused and perhaps underestimated and perhaps deliberately manipulated by some. The stakeholders include all sorts of stakeholders who they include the African states and the AU, the United Nations Security Council. We've heard some very legitimate criticism yesterday. Very, very big problems around the first office of the prosecutor and a complete abdication of disciplinary and oversight responsibility by the Assembly of State Parties. The incidents, and I'm just giving sound bites because I have to be done by 1:15 and then, but I will have ruffled sufficient feathers by then, don't worry. The management of virtually everything, self-referrals, the management of Security Council referrals and deferrals, the complete disdain for the debate about deferrals. As unpalatable as I find the idea of a deferral, but it's in the statute and it needs reconsideration. The management of the indictments of senior state officials, appalling timing. The management of pro motu proceedings by the office of the prosecutor, and the management of oversight. Now, the arguments about bias are on different levels within state societies and vis-à-vis other regions, because the fact of the matter is that self-referrals were used by African states as a way of ridding themselves of rebel movements. And their cooperation basically extended to the point that they could rid themselves of the Lord's Resistance Army. And, you know, we don't think that that as such is a bad thing, but there was significant resistance when it came to cooperation with arresting people in government. Ugandan president, wonderful example. He was very keen to get rid of the LRA and is now a very vocal opponent of the ICC. The prosecutor's office played into this repeatedly. Alienating victims. How do you explain within societies why only one group responsible for atrocities are prosecuted and others are not? And there is a risk that this is happening also in the Ivory Coast, the Côte d'Ivoire, regarding the pro motu situation, where only the Gbagbo side has thus far been prosecuted. Security Council referrals. Now, let me first say the African states themselves were represented by states on the Council with both referrals, Sudan and Libya. None of these states objected to the referrals. And in the case of Libya, actively supported them, despite the fact that they all know how selective the Council is, that it protects its chums and, you know, that it is a highly politicized organ. So there is an element there of African states just to turn around and say, well, why are you picking on us, is very disingenuous. That being said, the selectivity, the cynical behavior, and Mr. Corral mentioned that yesterday, of not backing up referrals with the necessary resources, and the complete disdain for how the deferral discussion was handled, and the African states also didn't handle it well, but just dismissing it out of hand, has not been helpful. I cannot explain to people, ordinary individuals, why the Syrian referral was blocked. We can engage, we understand why. But try and explain that to ordinary people, as well as, referrals of other countries. The timing, indicting a head of state, either by means resulting from a referral, a Security Council referral, or ex pro motu, at a time when this individual is already in power, either as a president or within a government, with state support and a regime behind him. What do you expect is going to happen? Do you honestly think the evidence is not going to disappear? That victims will not be targeted? The consequences for victims and witnesses in the Kenya case were atrocious. And why was it necessary to indict people at the time that they were indicted without thinking through the consequences of those cases? And also, especially in the Kenyatta case, he really used this to play into nationalist feelings in Kenya. Remember, the Libya war was going on at the time. Libya was being bombed at the time. There was also the referral of another African country, the indictments of another head of state. And as we now know, the then prosecutor was actually engaged. He was engaging with the UK and France at the times of the bombing to coordinate their regime change with his indictments. How do I explain to people that this is not an African bias? And just finally, and two very short remarks because we're now out of time, also the fact that until 2015, there was only ex pro motu initiations in Africa and only very recently in other countries without, as of yet, any meaningful results is not helpful. And finally, ladies and gentlemen, and I will stop with this, probably the biggest historic error of all, the spinelessness and the lack of courage and the cynicism of the Assembly of State Parties for not recalling the first prosecutor already in July of 2008, when the administrative tribunal of the ILO had found him guilty of abuse of power internally. How can somebody who has been found guilty in such a manner live up to Article 42 of the ICC statute, high moral character? What is the credibility of such a court? What is the credibility of such an Assembly of State Parties? And that all the very ill-advised policy decisions that I just briefly mentioned followed after that period. Could we have spared some of these happenings had the Assembly of State Parties done their work? The damage has been done. He may have departed. His legacy and the undermining of trust is still very much with us. Thank you.
Thank you, Erika, for your comments. I think this idea that international justice is one-sided, it actually triggers some historical memories. But it's very much something that can be addressed within the ICC system through prosecutorial strategy. As well, I think the debate on immunities, which we're now having, is a debate that can be addressed as part of the legal process. And also the debate on the choice of the prosecutor, whatever you might think about the choice of the first prosecutor, is a debate that you can have within the framework of the ICC statute. So my fundamental question is, what would then drive some of these states to exit from the system, although many of the debates can be addressed within the system? And secondly, what are some of your constructive suggestions on how this could move forward?
Well, I think there is a real concern amongst African head of states that they may be next. You know, we're not a particularly democratic continent, and we have a rather poor track record when it comes to human rights protection in general. So I think there is a serious concern that the court may actually have teeth and that they may be the next in line. But I also think that this goes deeper. The poor engagement, let me put it this way, through many of the first years of the existence of the court, the communication between the court and the African states had not been optimal. The factors which I have mentioned to you are very real. It's very disrespectful. There are huge ethical questions of how many issues were managed. So my point being, there's really a lack of trust. We need to rebuild the trust. Now, how do we do that? Briefly, I think we need very solid reasoning from the appeals chamber now in the case regarding Jordan. It was not helpful that the trial chambers changed their reasoning 3 times in something like 3 years. And I'm saying this is somebody who's on record in writing that South Africa had to surrender, arrest and surrender, and I am deeply ashamed of my own country's behavior. So I'm not saying this is somebody who's, against the prosecution, but we need a good argument coming from the appeals chamber, good reasoning. What else to do? We must really be very, very sensitive around the issues of new colonization, that we are dealing with many heads of state who will make this process work for them, but then retreat when they and their chums are somehow the ones being prosecuted or targeted. I think it's very important, this has come up in several panels, make true on investigating energetically other regions and come up with tangible results. It's going to be very difficult. The political contexts in many of these countries are increasingly difficult, but we have to stop whining about that. The court works in an extremely politicized environment. It's never going to change. International criminal justice beyond the state, it's always a politicized process. We have to work with what we have. We will never have enough resources. We just have to get over it and organize ourselves around this. So we must find a way of meaningful prosecution in other regions so that we see this is not only an African court. We have to strengthen, and we've discussed this in the previous panel, I think it's crucial, mechanisms for better national and regional prosecution, whether through hybrid chambers in national jurisdictions, through the kind of Central African Republic mechanism, Pakiso, which you've mentioned, considering medium-term regional criminal chambers in ECOWAS, East African Court of Justice, and so on. It needs to be, and then they have to work with the ICC. This is a medium-term, but it's very, very important. And finally, as unpalatable as it may seem also to me, we have to reconsider the deferral mechanism. It may save face in one or two instances. And the African countries are there, they need to come up with a decent procedure. How do they envisage this? How should we do this? They have not yet managed to do so. I do not think that it is good for the Security Council just to dismiss these discussions every time. And finally, and very provocatively, the best use of Article 13b is no use of Article 13b. We do not need any more referrals at this time. They will always be very politicized, protecting some and targeting others. Let's be modest. Let's work with what we have. Let's work with countries who have actually ratified the ICC statute or are willing to, on an ad hoc basis, Article 12, work with the court. Thank you.
So thanks so much, Erica. I think, again, if I reflect on these suggestions, first of all, solid reasoning on behalf of the court. That's something that can be done within the court system. More sensitivity to some of the tensions that basically ICC exercise of jurisdiction causes. That requires maybe different strategies on outreach, different strategies on cooperation, listening basically to the argument that are put forward. Again, that's something maybe within the procedure that could be addressed. Your third argument has been about regional mechanisms, so a little bit flexibility on behalf of the international criminal justice system towards regional mechanisms. You yourself formulated a criticism earlier on the African protocol, saying it's been all-embracing in terms of its jurisdiction. So, it's something which might merit a discussion on its own. And then you said this relationship to the Security Council. That's something that deserves future reflection. Let's now move on to Professor David Scheffer. He is one of the architects and one of the most, I think, vibrant voices on the emergence of the ICC statute. We all remember him as chief of the US delegation and the negotiations and the long discussions that he also had with many of the people in this room. David, you've been instrumental in securing the signature of the US to the ICC statute. And under the Clinton administration, you played a crucial role in actually advancing and promoting a constructive relationship between the ICC and the US. So from your perspective, how did this relationship develop over time, and what do you see some of the possibilities where future progress could be made?
Thanks very much, and I want to thank Klaus and Vivian for putting forth another stellar Nuremberg Academy event, which I'm very honored to be part of, along with my distinguished panelists. Well, you have asked me, Karsten, the U.S. question, and I do want to migrate, frankly, to to a broader discussion that does not necessarily include the United States, given the occasional futility of these days of incorporating that nation into our discussion. But I do think that the relationship of the United States with the International Criminal Court reflects so commonly other types of relationships that the United States has had with multilateral institutions over the last century. I was just reading a book recently that sort of cataloged the long journey of rejectionism by the United States Senate of multilateral engagements going all of the way back to the late 19th century. And it led me to reflect that, yes, we are in a rut with the United States on the ICC under particularly the current administration and what has been stated very recently. But let us remind ourselves that we've been in that rut many, many times before, and the United States occasionally crawls out of that rut and actually does the right and bold thing. Mr. Bolton referred to the righteous might of the United States, and I would turn that word around and say the righteous revival of the United States is desperately needed. And we'll have to see over the coming years whether that can be achieved or not. And I do want to get to Mr. Bolton and that relationship and whether or not we can make any progress with respect to international criminal justice in the current circumstances. But if I may, given the limited amount of time, I actually would like to put some ideas down on the table. The first one is on, if that's okay, Carsten. Yeah.
Of course.
Yes. And that is, and I've given a lot of thought to this. I published an essay in the UCLA ICC forum, on the web with the Office of the Prosecutor recently in their latest edition. And what I did was I tried to put forward an idea there that there be created, preferably through the Assembly of States Parties, but not necessarily. It could be simply the President of the Court that establishes this, a select committee on state party representatives that would bring together individuals from foreign ministries and justice ministries of key state parties to the ICC who are prepared to carry the water of the ICC in diplomatic, political, underlying political discussions with non-party states as well as states parties which are in the obstructionist or in the non-cooperative phase of thinking about the court, or who have, frankly, I think as Erica would agree with me, have perhaps some very legitimate complaints about the court. Well, let's sit down and talk about them. And you cannot sit down and talk with them as the prosecutor. You can't sit down and talk with them as one of the judges of the court. They have to act in a very independent, objective capacity. You need individuals very conversant with the court who live within the political dialogue of daily international diplomacy to sit down with various governments that have problems and discuss those problems more or less as, I don't want to say as agents of the court, but as individuals who are from state party governments, but are also part of the daily grind of foreign ministries and of justice ministries, and they understand what these problems might actually be that are being expressed by another government, whether that be of a non-party state or of a state party that's having difficulties with the court. And the suggestion in the essay is how to select that select committee, and to do so perhaps with 20 members or so that would have 2 or 3 year terms, whereby they would take this duty on as committed state parties to the court to try to get this dialogue right with other governments. And to be able to do so with political dialogue and not having all sorts of shields and blinders on because of their professional capacity with the court itself. They don't have a professional capacity with the court. Their job is with their foreign ministry. So they can speak quite freely about how to solve problems. But we need governments to do that. The idea that governments delegate to the International Criminal Court the lobbying of the court's equities with governments, I think is extremely short-sighted. You need governments lobbying the equities of the ICC with other governments. And that includes, by the way, the equities of defense counsel. So often, the individuals who are being targeted by the court, of course, are individuals who might have a substantial posture within a certain country, so, i.e. a leader, or someone who's running for president. And the defense counsel are going to be in there slugging away. Well, they may have some pretty good arguments. And you need governments to be able to express sort of on a political basis, yes, we understand where defense counsel are coming from on this. We also understand where the prosecutor is coming from. We need better cooperation for both sides of the equation. And anyway, so it's an idea that I think plays off of, I think James Goldston was suggesting this as well, that there's a political factor in complementarity with governments, and I'm trying to emphasize that. Secondly, I'm so pleased with the collective referral on Venezuela. It's been a long time that, you know, when we were negotiating the Rome Statute, we just thought it would be state party referrals, and sometimes the Security Council would step up to the plate, thank you. But we really did not contemplate self-referrals, and we kind of didn't think there would be at least in my mind, I didn't think there would be a proprio motu surge of preliminary examinations to the extent that we've seen them, and that's fine. I'm just saying our expectation was that there would be state party referrals. And that did not really come to pass, I think politically, because states don't see it in their political interest to make those referrals. But if we can get to a posture of more state party referrals, we can avoid this whole preliminary examination trauma with the Office of the Prosecutor. And I think the prosecutor can operate more effectively and efficiently and transparently as opposed to this long journey of preliminary examinations that we've endured. Now, I want to very quickly, I'm going to tick off some things that go back to the Nuremberg principles, et cetera. In the Security Council, you know, we've always had this dilemma with the United States in particular of can there be reference to the International Criminal Court, et cetera, in various resolutions, and what about the exposure of non-party state nationals, et cetera, to the ICC? Those are huge issues in Security Council resolutions. They get thrashed out. But it might actually be a good alternative to sometimes say, well, yes, there's the Rome Statute and all the atrocity crimes which are there, and let's validate it with the Security Council doing so, which then causes political problems. But you can also just fall back occasionally on the Nuremberg principles and just have the Security Council actually validate the Nuremberg principles, and I don't think the United States could possibly stand in opposition to that. So keep that in mind as a possible tool within the Security Council and the General Assembly itself if there's this, particularly under the current administration, I'm sure it's going to get tougher and tougher to get the ICC into various UN resolutions. Next point, I strongly believe in much more work on prevention issues which can clearly bring the United States into the forefront on prevention. And I won't go into detail on it, but I strongly believe in the need for policymakers to have much better understanding of the costs entailed in preventing and not preventing atrocities before they build into complete calamities. Policymakers need to be impressed with, you let this go on and you've got a hell of a cost ahead of you. I think we can, in the Assembly of States Parties, in recent years, of course, it's been consumed by the Africa debate and by the budget. And I would propose, why not have an agenda item at the Assembly of States Parties entitled Building Bridges to Non-Party States, the year of building bridges to non-party states, and really coherently put together a political initiative with the ASP behind it to build bridges, to have conversations, to have meetings, to have symposia with relevant individuals, not just academics, please, but relevant, government individuals, et cetera, in non-party states to really have an ASP dialogue with non-party states, and I think everyone could get behind that, quite frankly. And then finally, non-party states can empathize with victims just as much as state parties. And I think that's an opportunity to sort of, again, establish more of a linkage with non-party states. If there can be methodologies devised to bring non-party states more into the work of the Trust Fund for Victims and what is required of the victim populations of these atrocities, and it doesn't have to have anything to do with the ICC at all, but it does create a bridge into what this whole exercise is about, which is not only accountability for the perpetrators, but also the fate of the victims themselves. I do have a checklist of bulletin points, but I will stop there.
Go ahead. No. You'll have to make a few arguments in relation to the current stance of the US towards the ICC and how you would see potential possibilities to affect progressive change.
I'll do this very briefly because this could be a long discussion, and it will not be. The concern I really have, and what I would reflect upon with the Bolton speech of a few weeks ago, is that it truly emboldened authoritarianism. It emboldened, the Myanmar leaders, Duterte of the Philippines, many others, to actually resist and walk away from the International Criminal Court. So that, and the principles for which it stands. So it's an interesting exercise that reflects perhaps actually the true spirit of the thinking within the current administration in Washington. And I think even the experience of the last week with Saudi Arabia continues to amplify a mindset shift that is simply going to have to be endured for a while before political life in America can be reversed through the democratic process. The speech used exceptionalism destructively rather than constructively. Now, in the Clinton, and I think Ambassador Rapp would agree also in the Obama administration, yes, there was an embrace of exceptionalism. Of course, it's how you define exceptionalism and then what you do with it. But I always thought that in the prior administrations, exceptionalism was embraced for the purpose of constructively engaging and leading in the world because of a certain exceptional identity that the United States had, whether you agree with it or not. That was sort of the theory we were working with, certainly in the Clinton administration, even though I didn't like the term, and in the Obama administration. In the current administration, it's used as a tool to destroy, to dismember, to disaggregate, to assault multilateralism. And even yesterday, John Bolton announced that the United States would withdraw from the Intermediate Nuclear Forces Treaty. So yet another treaty, just after the Postal Treaty went down a week ago, has now been dismembered. So it is a constructive approach rather than a constructive one. A lot of hyperboles, a lot of inaccuracies. I'll just point to one because there are so many in the speech. But he goes on and on about the crime of aggression when there was no need to do so for the United States. I mean, I know Ambassador Venevesar, I think, would agree that that was a hard-fought issue, and Ambassador Rapp, that yes, there is aggression now available as an amendment for countries to sign up to, but the United States is not exposed to the crime of aggression before the International Criminal Court, and probably few of its allies will be in the near future. So it's a concern that was irrelevant completely and very misleading in his speech. I would say that the future, the near-term future of the International Criminal Court with the United States can be structured, regardless of Mr. Bolton's punitive ideas of, prosecuting and sanctioning prosecutors and judges. And by the way, unless someone out there is really on top of this, I have not heard of any credibly sound basis upon which he has made that statement under U.S. federal law. Now, maybe he can get there. It will be challenged, but the idea that he flippantly threw that out without any sound legal basis that I know of is interesting. We have in the United States politically sort of a movement that calls itself the resist movement, and of course it's all about, the political dynamics in America. But in the judicial realm, there's also sort of a concept of resistance in American society among, first, the majority of the American people support the International Criminal Court. Every credible poll, the Chicago Council on Global Affairs poll just a couple of months ago, confirmed it once again. Large majority of American people support the International Criminal Court. So there you have the view of the American people. So they also, by a very large majority, supported the League of Nations, and the US Senate still never ratified the Versailles Treaty and the Covenant. There's not only the people, but there's also civil society. There's a huge, some of them, they're in this room, of course. There's this whole infrastructure in the United States and civil society which is not only supportive of the ICC, but assisting it in an enormous way. So I think that has to be recognized and certainly drawn from. And then finally, there's a tremendous amount of wealth in the United States that demonstrates itself through philanthropy and the pet projects of very wealthy individuals now. I think that can be tapped in many significant ways for the purposes of international criminal justice and the International Criminal Court. So with that, I have others, but I will leave it at that.
Thank you so much, David. I think your remarks are really on point. You suggested a new mechanism to actually build bridges to non-state parties as part of the ASP, and to maybe focus also on shared interests that the ICC has basically with non-state parties. And I think the Myanmar situation is certainly one where US interests might to a certain extent coincide with the interest of states parties. You also suggested that there should be a platform to listen to concerns, and which accommodates a broader platform of professionals. And you also said that maybe the preliminary examination process is something that might deserve attention. I would now like to give the floor to Professor Bakhtiar Tuzmukadev, known as Judge T, former judge of the ICTR and the ICTY. He's vice president of the Russian Association of International Law and member of the Committee Against Torture. And hardly anyone knows that Russia actually was a signatory to the Rome Statute, and in 2016 it actually decided to withdraw its signature. So the first question I would like to pose to Judge T is, under what conditions could the ICC expect Russia to be re-engaging and signing the Rome Statute, and what negotiations have been taking place, if any, towards that goal?
Thank you, Karsten. Well, actually, the rule of the courtrooms in which I had the privilege of sitting as first a trial judge and an appeals judge was the advice to parties who would have difficulty negotiating through all the intricacies of my name to address me either as Judge T, or if they wanted to be exceptionally polite and nice to me, then it should be Judge BT. However, Dr. Zhu would confirm that BT has some negative connotation in Mandarin language. Is that so? Yes, you can see that. Let me at the outset make two administrative announcements. I certainly subscribe to the praise which has been given multiple times here yesterday and today to the organizers and leadership of the Institute and to its able staff. But I should also like to echo what Karsten said, and that There is a particular person who was very instrumental in putting together those panels, and in fact, many of the panelists, including myself, received sailing orders from Eduardo Toledo, and that enormously helped to organize thoughts and actually to create those thoughts. And if this is being recorded, can you please share this with Eduardo, who is out of the room now? And secondly, I think it's ironic that Karsten was asked to moderate this panel, because to those few uninitiated in this room, Karsten edited a huge volume on law and practice of ICC. And as someone who had to deal with a group of authors numbering 17, I can hardly imagine how can you lead into battle the legion of 58 authors, each one with his or her own opinion and worldview. However, in my review of that volume, Karsten, you would recall that, I identified as a single most substantive deficiency the lack of any chapter that would be written by an author from a non-engaging or disengaging country that would deal with issues of non-engagement and disengagement. Of course, there were some authors whose origins could be traced back to nationally or educationally to those non-engaging or disengaging states, but they were addressing different issues. Karsten, you're right. Russia signed the Rome Statute on 13 September 2000, and this was ordered by the President. Interestingly, the order was initiated by the Foreign Ministry, joined by other stakeholders, including the Prosecutor General's Office, the Supreme Court, Ministry of Justice, Ministry of Defense, Federal Security Office, Federal Security Service, and even the Foreign Intelligence Service. After that, in early 2003, the President instructed the Ministry of Justice to draft the legislation, actually the law on ratification of the Rome Statute, but that working group went further than the instruction of the President, and apart from drafting a simple law on ratification, thus making Russia a party bound by the terms of the treaty, they also drafted multiple amendments to the international to the criminal code and criminal procedural code. They submitted their recommendations in 2005, and they completed their mandate, and the Chief Legal Advisor's Office of the President's administration said that further work needed to be done, and nothing happened. To the best of my knowledge, the last official comment coming from the Foreign Ministry that positively discussed the feasibility of Russia's ratification of the Rome Statute goes back to July 2009. Statements made by Russian delegates in Kampala were quite positive, but they did not specifically address the issue of ratification. There has not been any further legislative or political action. There was no submission of the treaty for ratification by the State Duma, the legislative chamber of the parliament. There was no appointment of official representatives of the President to represent the high office during the ratification procedures. And so the only official public subsequent action by the President was the decree which was promulgated on 16 November 2016, by which Russia declared its intention not to become the party of the Rome Statute. Interestingly, and that probably echoes, Karsten, your question about conflicts, frictions, different attitudes between various government departments. This one was initiated by the Ministry of Justice, not the Ministry of Foreign Affairs that would be a leader. Whether this is reflective of any of those frictions, I don't think. I think that this may be attributed to the fact that since the signing, much of the burden of representing Russia's interests in international courts and tribunals, I should qualify that, mostly in the European Court of Human Rights, moved to the Ministry of Justice, and so they are the primary stakeholders in Russian representation at that ministry. Actually, My experience, my brief and very modest experience with the Committee Against Torture proves that in the United Nations human rights treaty bodies, the Ministry of Justice now takes the lead. So as to unsigning, you know what? I do not subscribe to the concept of unsigning. I think that once signed, the signature belongs to the treaty, and its custodian is the depository of the treaty. And the signature stays there, whether it's active and then translates into the instrument of ratification, or it is just hibernating somewhere in the domain of the depository is a different question. Also a different question is what takes to interrupt the hibernation of that sleeping beauty, and what prince and what actions on behalf of that prince that would require. So as to negotiations, I have not been part of or privy to diplomatic processes that culminated in the adoption of the Rome Statute or other events, whether at ASP or the review conference. However, I have sound reasons to believe, and hopefully Ambassador Scheffer would confirm that the Russian delegates, both in Rome and in Kampala, negotiated in good faith. However, in all candor, Eduardo, I cannot repeat all the praise that I've given to you while you were away, but there is a recording which will be shared with you, okay? So in all candor, I should say that chances of ratification by the time of the review conference have slimmed down as compared to the period immediately following the Rome conference. As to domestic processes, I'm aware that back in 1999, the State Duma, again, this is the legislative chamber of the state parliament, had been contemplating parliamentary hearings on the feasibility of ratification of the Rome Statute. I was asked to write an opinion for those hearings, but my opinion, and actually my interest, my knowledge of this volume is largely limited to the possible issues of constitutionality of the Rome Statute. I'm not aware of those hearings ever taking place. However, the Russian Association of International Law initiated expert hearings at the parliament, and that expert meeting was held at the State Duma in December 2001. The two lead-in presentations were done by Ambassador Kirill Gevorgyan, who was the deputy negotiator in Rome, and at that time he was deputy director of the legal department, and Kirill is now the judge at ICEJ, and yours truly was the other presenter at those hearings. Kirill discussed the Rome Conference and the statute, and I addressed possible issues of constitutionality, that is compatibility of the Rome Statute with the Russian Constitution, and ways to harmonize the Rome Statute and the Constitution. Now, when Philip Kirsch, then president of ICC, visited Moscow in February 2004 to meet with Russian officials and to speak at a conference, my name had been struck off the list of principal speakers at the 11th hour, maybe even at 11:30, maybe even quarter before. Such was the mood prevailing at home at the time that no one wanted to have a speaker who might upset the good president of ICC by remarks about possible constitutionality and thus inability of Russia to ratify without first putting the Rome Statute through the judicial review. That notwithstanding, a private meeting was set up for President Kirsch and myself, and we had a long and I think very good chat. And it turned out recently that there was some photo evidence which I shared with Philip. And Philip, I'll be sending you a high-resolution file with those photos. So,
can I just ask you?
Yeah.
How would you see the discussion moving forward? Obviously, the Russian approach. Now came at a time when the ICC started its preliminary examination and authorization in relation to Georgia. So it might be coincidence, it might not be coincidence. But how would you see relations developing in the future? What future steps could the court take to improve the relationship?
When my wife tries to foresee the events, she never uses the phrase "not in my lifetime." I'm inclined to use this phrase now, though I'm sure that many people would not like to hear that. I would not expect any political or legislative action with respect of the Rome Statute in any foreseeable future. Of course, that brings me to my statement that I do not share the concept of unsigning the treaty. But again, I cannot foresee what course of events would lead to the reactivation of the process, and that is to interrupting the hibernation of the Sleeping Beauty. Now, I could have some ideas as this discussion moves forward, or I could address them now. What is happening, what has been happening, has not been happening on the official level. And while Ambassador Scheffer was referring, David, you sort of brushed aside academics. You said not academics, but officials. Okay. What has been happening prior to Russia declaring its intention not to be a party, and even afterwards, were multiple contacts that we have developed, and I can look into this audience. Talking about academics, we've had distinguished academics like Bill Shabazz visiting and talking to his counterparts in Russia, and of course some audiences included officials. Judge Ushatska has been a regular visitor to Russia, and not only being a judge at ICC moot courts. Incidentally, we've had since 2012 ICC moots, the Russian language version of ICC moot, which would have the finals on the ICC premises in The Hague. Judge Song has modestly moved back into the gallery to join the real people, but last year Judge Song was the guest at one of our conferences and addressed the group. I will have the privilege of moderating a panel on evidence in international criminal procedures in 2 weeks' time, and that panel would include ICC Judge Kim Prost, the president of STL, another frequent visitor to Russia, Judge Ivana Hrdlichkova, former chief prosecutor, former senior prosecutor at ICTY and his own Canadian jurisdiction, Peter Kramer, and of course Lord Bonamy, who is a retired ICTY judge and retired senior judge of Scottish High Judiciary. And I should specially mention that this sequence of interaction with ICC judges was started by the dear friend of many of ours here in this hall, Hans-Peter Kaul, who was the guest of one of our conferences quite a few years ago.
Thank you so much, Judge T, I think, for sharing your reflections. Judge Beatty? I think if there are consequences, that there's no concept of unsubscribing. There are, of course, interesting questions in relation to the Vienna Conventions on the law of treaties. What does it mean in relation to not to defeat the object and purpose of the convention? Secondly, you made a very interesting proposal to keep discussions on a non-official basis in order to keep relations. I think that's a really interesting suggestions. We now move on to Dan Zhu, who is Assistant Professor of International Law at Fudan University, and she's a member of the Chinese Bar, and she's just published a book on the relationship between the ICC and China. So I think it's wonderful that we have her here. China expressed some objections to the ICC statute, for instance, their rejection of individual criminal responsibility in non-international armed conflict, whether that reflects customary law. So that might be an objection that might be very much in flux, also in light of the existing development in international law. And then China had some more objections to the also independent role of the prosecutor, and that, of course, might cause probably more fundamental objections as to how China could be brought forward and approximate its relation to the ICC. So my question to you is, what is the current position of China vis-à-vis the ICC and the adoption of the Rome Statute, and have you observed actually any changes in the Chinese position?
Okay, thank you, Professor. And good afternoon, everyone. And I would like to first thank Nuremberg Academy and also Klaus and Vivian for organizing this great event and also for having me here today. And I'm very privileged to speak among those distinguished panelists. And I like Professor Scheffer and Judge BT, who are in the position to share internal perspective about US and Russia's engagement with the International Criminal Court. And my reflection about the Chinese perspective are almost based on the Chinese statement and also other public available resources. And also, unlike the shifting position of US and Russia towards the ICC, which from signing and to unsigning, China has a much more consistent approach towards the court. We actually actively participate in the whole process of the negotiation of the Rome Statute, including the ad hoc committee and the preparatory committee, and also most importantly, the Rome Diplomatic Conference. And in the course of the negotiations, the Chinese delegation identified and also raised several concerns, specific Chinese concerns. And some of these concerns were actually taken on board at that time, and some of them remained outstanding at the end of the Rome conference. And as we all know that China voted against the Rome Statute together with US and Russia and also several other states in 1998. And even after the Rome conference, China still keep an active interest in observing and also participating the development of the court. And China, as an observer state, participated in the discussions of ASP meetings and also the discussion group and also the special working group on the crime of aggression. And also, China was part of the Kampala Review Conference, even though the outcome of the conference was not in China's best interest. So, as a permanent member of the Security Council, China actually didn't use its veto power to block the Security Council refers in Darfur or Libya to the International Criminal Court. And also, on many occasions, China expressed its explicit support for this code. So all these kinds of engagement indicate that China was and still is interested in moving towards more direct or full participation in this court. But there are also several reasons and concerns identified by the Chinese authorities as barriers preventing China from joining the court. So the question is, what are these objections which will play a central role to China's relationship with ICC? And actually, these concerns were formulated and articulated by the Chinese authorities in very strict legal terms. And we all know that there is a tendency for government to address policy concerns as legal concerns. So these concerns are actually a reflection of the policy preferences of the Chinese government. And actually, these concerns as a whole is very unique But some of the concerns actually are being shared by other prominent members of the Security Council, including US and Russia. And also, it reflects the concerns of some developing states, especially those who insist a very strict concept of state sovereignty. So in the context of the International Criminal Court, China is actually finding itself being seized in this kind of seemingly very conflicting identities. When on one side is a permanent member of the Security Council, but on the other hand, it is still a developing state. And especially on the issue of the crime aggression, it's very clear that China is having this kind of two double identities. And actually, being the biggest victim of Japanese aggression during the Second World War, China has good reason to see the criminalization of aggression under a permanent basis. And China indeed had been very supportive of including the crime aggression under the jurisdiction of the court. But China has concerns about this crime on two major issues relating to aggression. And one of them is actually shared by the permanent members of the Security Council. And China, and I think also US and Russia, they share the view that the International Criminal Court should not be allowed to prosecute the crime aggression without a prior Security Council determination of the state act of aggression. And from a legal perspective, this kind of proposition has already been subjected to very critical academic examination. And the likely conclusion is that although the Security Council has a primary responsibility in maintaining international peace and security, but this shouldn't be exclusive. But from a policy perspective, I think there is a legitimate concern of the permanent members to think that the prosecution of crime aggression by the ICC could actually compromise the mandate of the Security Council in maintaining international peace and security, in which all the permanent members are entrusted with a special responsibility. And in addition to this concern about the role of the Security Council, China also has concern about the definition of the crime, especially the state act of aggression essentially touch upon the area of the law on the use of force. And the use ad bellum international law, although it's very clear in the core context, has been surrounded by many legal controversies, such as self-defense and also humanitarian intervention. And the Kampala Review Conference was unable to clarify these ambiguities. Although they introduced this kind of manifest threshold with a few understandings, it might not be sufficient to alleviate the Chinese concerns. And actually, it can be recalled in history back in 1951, when China considered itself has exercised the collective self-defense in the South Korean peninsula, and the General Assembly nonetheless adopted a resolution condemning China as an aggressor itself. So afterwards, China was very key in drawing a clear line between aggression and self-defense. And we are not being able to get it during the 1970s, when the General Assembly adopted a resolution defined state act of aggression. And then the Rome Statute and the amendment in Kampala equally was unable to clarify this issue. So the ambiguities are still there, and they might actually affect in the future how China could comfortably employ its military force, especially given the high risk of armed conflict in South and East China Sea, as there are the sovereignty and jurisdictional claim between China and its neighboring states. And also on the issue of humanitarian intervention, China only supports humanitarian intervention under the authorization of the United Nations. So there is really, it's not in China's best interest to accommodate any interpretation that could actually exclude the humanitarian intervention without Security Council authorization from the jurisdiction of the court. And apart from the definition of the crime of aggression,
Yeah, okay.
yeah, I will just briefly to introduce, okay? And China also has concern about the definition of crime against humanity and war crimes. And actually, during the negotiation process, these definitions are required to reflect customary international law. And obviously, China has different understanding about the context of customary international law regarding both crimes, especially crime against humanity committed in peacetime and war crime committed in non-international armed conflict. And actually, during the negotiations in the 1990s, there were debates, there were discussions, and the customary international was not entirely settled. So there were actually legal merits in Chinese argument. But after the adoption of the Rome Statute, and after 60 ratification, now it increased to 123, I think it's difficult for China to argue against the customary statute of these two crimes. And also from a policy perspective, I think these concerns are alluded to China's domestic situation and also challenges. And China would be very much concerned about any external intrusion into its domestic affairs, just under the pretext of human rights. And I think lastly, China also have concern about the jurisdiction of the court, especially the complementarity jurisdiction, even though we support it in principle, but we're concerned how the principle complementarity was eventually incorporated in the Rome Statute in the context of admissibility, especially the criteria of unwillingness, because there are so many ambiguities regarding this criteria, and it's uncertain whether the violation of the fair trial rights of the accused would actually render the case admissible before the court. And from a policy perspective, actually, China has been keeping distance from international human rights mechanism that would actually subject itself to any scrutinization, but we made exception of international crimes. But the main purpose for the ICC was to end impunity for the most serious human rights violation, which is international crime. But if the court in practice take on the role of a human rights court examining state compliance with international human rights standard, then it will actually disengage with China and also other states who share similar concerns with China. I think due to time...
Dan, could you move on maybe to some of the suggestions about how some of these concerns could be addressed?
Sure. I think because when the Chinese concerns were articulated, it was almost 20 years ago. So we are only being able to articulate it in very abstract terms. But now since the court has been operating for more than 2 years, and there is opportunity for us to examine all the development in the practice and also the amendment of the Rome Statute, but also the customary international law, to examine whether the concerns of China has been materialized in the practice of the court or the concern has become less robust. So then that actually depends on how the court perform in practice. Because I think China would envisage a court that have a few key characters such as impartiality, independence, effectiveness, which would be basically supported by everyone. But the special Chinese version of the court, I think, would at least address some of these Chinese concerns concerning state sovereignty. Even though not all the concerns are resolved along the Chinese thinking, but I think it at least should provide a certain kind of comfort to the Chinese authority. For example, the crime of aggression, we didn't like the definition, we didn't like the way how it relates to the Security Council, but we can actually opt out of this aggression. But this mechanism is actually not available to other crime against humanity, and war crime. So then it would actually come down to the complementarity regime, which will only come to play in the phase of admissibility. And then if the court actually play a role of a human rights court during the decision of the admissibility, so it actually have a very negative impact on future China evaluation of its relationship with this court. And I think it's really, because the Rome Statute is now closed, there is no realistic perspective that it could be renegotiated or amended. So the practice has become the only dynamic way that we can actually have a conversation and to have a realistic perspective of this court. So I think it really depends on whether the ICC can establish itself as independent, impartial, and effective court.
So, thanks so much, Dan. I think you made the point that in order to improve the relations to non-states parties, the ICC has a signaling effect in relation to its performance. So how efficient and effective the ICC is might make a difference, and also how it approaches issues of jurisdiction and state sovereignty will be key to a Chinese perspective. I would now like to open the floor for discussions, because I think we have tremendous expertise in the room. I would first of all give the floor to Hans Corell and then Kamari Clark to make the opening.
Thank you, Hans Corell. 4 quick points, and now I speak in my capacity as former legal counsel of the United Nations. Unsigning, there is no such thing. In December 2000, I realized that the Office of Legal Affairs would be closed on the 31st of December. And I said for myself, for heaven's sake, shall we prevent states from signing the Rome Statute the last day indicated in the treaty? So I circulated a note saying that the Office of Legal Affairs would be open on the 31st of December 2000. I received 3 signatures. David Scheffer, who came with the US signature. The other 2 signatures were Israel and Iran. It's a very interesting combination. Then I received a message from the US in 2002 that they wanted to unsign the treaty. And we examined this in the legal office, and we came to the conclusion there is no such a thing as unsigning. It's a historical fact that the treaty was signed. But I then offered the US, why not send to the Secretary General a note indicating that you no longer stand by the signature and you have no intention to becoming a party of the treaty. So this they did. And then we introduced this in the treaty collection. And this happens also to Israel. On the 6th of May 2002, the US note was entered into the register, and I just checked it again. And then Israel had a message on the 28th of August 2002, and then Russia had signed on the 13th of September 2000, and they sent a note on 30 November 2016. So this is in order now, but it should be shown to the world that yes, there was a signature, but they do not long stand for that. So therefore, we should not talk about unsigning. Second point, the comments by John Bolton. I think it's really very sad, and I mean, parts of it is simply so uneducated that I get sort of worried when I see this. But I remember that I had a discussion with John Bolton at New York University in 2001 or 2002, before he became ambassador to the UN. In that discussion, he denied the existence of international law, something which your founders already in the 18th century understood. Look at the Supremacy Clause in Article 6 of your Constitution. Third point, this is the question of the African states convincing the Assembly of States parties to introduce rules about the presence of people accused before the court. And I wonder if these rules are still applied, because I would have thought that the court would throw them out as violating the Rome Statute, because they are not in conformity with the statute, those rules applied. And this brings me also to the question of complementarity. There is a very specific situation where complementarity cannot be applied, and that is if the evidence leads the prosecutor to the head of state, because the head of state would be immune under national law. And this is why the ICC is there, precisely to reach people at this level. And that is why some states do not want to become parties to the Rome Statute, because the heads of state there might think that they would soon become suspects. The fourth and last is the reference under 13b that Erika de Wet mentioned. I always saw 13b as a rational provision in the Rome Statute, that you didn't have to establish a new court if you had a Yugoslavia or Rwanda situation. When you have a court that is up and running, why not use that? On the other hand, I think, as I said before, we should have alternative means also, and this is why I referred to the handbook by the Open Society, and Jim Goldstone is here now also, I see in the audience, but I think that you should study this one and see how we can assist the ICC by having other methods also. Thank you for your attention.
Thank you so much.
Hi, yes, again, Kamari Clark.
Stand up.
Okay, sure. So, Kamari Clark, I wanted to ask a question or push a bit on this point of unsigning and withdrawals. And indeed, this panel is a panel that pushes us to think about these retractions and engagements and the state of affairs in the contemporary period. And one of the things that I think we really do need to do is to think about both the expressive and instrumental role of the law. And in particular, I'm reflecting on a point that Judge BT made, and that many make, that there is no such thing as unsigning, but I'm also thinking about the realm and the role of withdrawals from the Rome Statute. And on one hand, it's important, of course, for us to think about the instrumental role of the law, so to think about the instrumental role of treaty signing, etc., as well as withdrawals, but there's also the expressive role of the law, the expressive acts of state agents who both step into a situation where they're unsigning or producing the possibilities for the withdrawal. And if we think about the expressive role, it pushes us to ask, well, what do these withdrawals do? Or what does unsigning do as a political act? And where am I going with this? Well, the question that I want to ask, and the point, in fact, that I want to make is that if we think about these retractions and withdrawals as expressive acts, in the same way that we have what many of us with the Malabo Protocol for the African Court call we often jokingly refer to it as the protest treaty. If we think about the expressive role of withdrawals, or even the types of the establishment of institutions that respond to political, what is by some seen as political inequality, then it means that we're asking, what do these withdrawals do? And how can these withdrawals, in fact, lead to possible and future instrumentalities? And I think in the African region that we do see some of that withdrawals are also productive of new ways of envisioning other possibilities, including other forms of jurisprudence, even as flawed as they are. So if you could, both BT, but especially Erika, if you could reflect with us on the expressive role of the law and how these expressive, these statements of withdrawals are also opportunities for possibilities. And if we think about these opportunities for possibilities, they open space for rethinking what law can be and what it can do, and how, there may in fact be new spaces for producing new instruments that respond to some of those both political and legal problems. Thank you.
Thanks so much, Kamari. I think your question is spot on about what empowering effects also might this move have. Does it empower civil society? Does it increase further resistance? Does it give a new role to courts in relation to this whole dispute? But I'm going to collect a few more questions now. Bill Chavez here in front, and Christian Veneve.
Yesterday, when we talked about the making of the statute, we only referred very briefly to the vote. And I guess we have David Scheffer to thank for this. It's not a recorded vote. He made it quite explicit when he asked for the vote that it wasn't to be, there was no request that it be recorded. And so there's still a little bit of mystery about who voted against and who the abstainers were and so on, and we continue to speculate about that. I think we know that both China and the United States voted against the statute. I was always intrigued about Russia and its position. I think it's generally believe that Russia voted in favor. But I wanted to relate to you just a little anecdote about that I heard only a few years ago over dinner from now Judge Gevorgyan, who was the head of the Russian delegation. And he said that it was up to him to take that decision about how to vote. And he said, I recalled that in 1948, in December 1948, I guess he wasn't even born then, but he recalled it, that Russia, or the Soviet Union at the time, had abstained in the vote in the General Assembly on the Universal Declaration of Human Rights. And he said, I thought about that, and I thought, a lot of good that did us. He said, we were misunderstood ever since. They explained the vote, but nobody knows. All we recall, he said, is that we'd abstained from this most important symbolic vote, and he said, and I wasn't going to do that again. So he said, I took it on myself to vote in favor of the statute and went back to Moscow the next week and had to explain why I'd done that. So I thought you'd like to hear that.
So much. Kirsten Winnevesen.
Well, thank you very much. Well, just a few comments. The US, of course, has attacked the ICC before, and the ICC has survived that. But that was a different time. That was not a time when anything having to do with international law was under assault. And this is why I think we have to look at this a bit differently. It's not so much about what John Bolton said, in my view, and it's really for you guys to examine the legality of actions that he has threatened. I think it's more about the overall dynamic and about the fact that there are a lot of people, jumping to the opportunity that they see that, to destroy this court at this point. And that was at the time not at the time of George W. Bush, there was a joint response in support of the court. And we don't have that much of that now. And a lot of people are hiding right now and talking about the attacks by the US, and I think it's a far broader attack. In July, we had a meeting in the Security Council, an ARIA formal meeting, and the Russian delegation said essentially, we do not know why these people are even showing up here anymore. We don't want to see them anymore in the Security Council. They're useless, and they're only coming here to tell us that we are useless. So that's a pointless dialogue. And I think that's the tone right now. And it's not just about Russia. I think it's about a large number of states. And I'm more concerned in a way about silent disengagement, because you have a lot of states that are parties to the Rome Statute but don't stand up for the court. If you look at who has spoken out in favor of the court during high-level week, I don't share what Fatou said, because she said she felt encouraged by the support. I thought it was disappointing. If you look at who did not say anything, and if you look at who these states are and what they would have said 15 years ago, I think that's a very bad sign. And I think that's how we have to look at it today. I'm not, I'll speak again in the next panel. I'm really not defending the court in everything that it does. And I think we have to look at the deficiencies. And I think there needs to be more political conversation with those who criticize the court. Absolutely. I think there should have been an Article 16 discussion. And I can tell you why it wasn't held. And it was not held because people felt it would be counterproductive to show that there was no majority for that request. But that, I think, again, is in a way a different discussion. I mean, what David has said in proposing a select committee, I think that's the right instinct. I'm not sure that the ASP will do that, but we certainly need people that stand up for this court in a different way than they have been doing so far. And really not in a sort of blindly uncritical way. I think that would be counterproductive, but in a way that shows that they understand the institution and they understand its weaknesses. On crime of aggression, I will also say a word on the panel. There is some buyer's remorse now, I have to say, because some people are criticizing things that they have accepted themselves, and in some pretty ironic cases actually proposed themselves. The role of the Security Council is one of these things. That was negotiated in Kampala with states present in the discussions that were not state parties, because we were looking for the highest level of political acceptance. And the provisions that he criticized on the definition were negotiated in the framework of the special working group where everybody was present. And China was there all the time. The US chose not to attend. China was there and participated and was part of that consensus of what was sent to Kampala. Thank you.
For these, I think, important contributions. I'm going to collect a few more interventions now, and then I'm going to give the floor to the panel collectively to answer. So, Navi Pillay here.
Why do I have to stand when you are seated, Carsten? I want to raise two issues. The second may be a bit controversial, but the first is in relation to China's rather fixed policy of non-interference in the internal affairs of states, the prioritization of national sovereignty, which is much more stridently raised now in all human rights issues. So how does that gel with international crimes? You know, would that be a block? Don't interfere in national affairs at all, irrespective of these serious crimes. The other issue I wish to raise is because the multi-state referral with regard to Venezuela has come up, that I want to recall that human rights people, the High Commissioner's Office for Human Rights, has always said that sanctions must not harm ordinary people. And so we tracked sanctions, whether imposed by the Security Council or by states, such as sanctions by the United States on Iran, sanctions by the United States and Europe in Zimbabwe, and sanctions against Venezuela. And so now I'm curious to see whether, if the evidence points to sanctions harming ordinary people to an extent where it amounts to crimes against humanity, maybe even genocide, whether the ICC could look into that aspect.
So much. I'm going to take one last question. Fakito?
Thank you very much. A couple of questions to each one of the speakers. Then, recently, during the course of this year, there was a moot court that was organized at the ICC and with the Chinese universities, and the Chinese participated quite actively. And notoriously, the Chinese embassy in The Hague participated in that, with the ambassador presenting accolade certificates at the end. We have seen more of a bit of a change in the Chinese approach. They've been coming to the court asking questions. Does this reflect any change in the attitude toward the ICC by the Chinese? Or what is your reading of this? Judge Beatty, a converse question on that. With regard to Russia, I mean, it's a converse question to what Carsten asked. What is it that can be done to mend the relations between Russia and the ICC? My question would be, what happened on the relations between ICC and Russia? There was a time that relations were just cordial. During our preliminary examinations in Georgia, Russia engaged. My team actually visited Moscow. They engaged in terms of exchange of information. But we have now seen increasingly some negativity from Russia in the context of the Security Council, in the context of the General Assembly, where the ICC is discussed. We see some negativity from Russia. I've just been wondering, really, what really happened there? What could have been the cause of that now that made Russia to... I would not personally, I don't expect Russia to ratify the ICC statute, but at least the relations that we used to enjoy with them, where they were just cordial relations, that has gone, and I was just wondering what was the reason for that.
Thank you, Fakiso. We have to, unfortunately, we're guilty of overrunning on time, so I think you...
Yeah, Erica, me and you can discuss the issues that we discussed for quite some time, yeah.
Thank you. Sorry, I cannot give the floor to more questions, but I would like now to ask our panelists to respond to some of the points. So, Erica, you're...
Just very briefly, Kamari, thank you. I actually don't think we need withdrawal to come up with new creative solutions. We've already discussed the way that rethinking complementarity, strengthening regional mechanisms, hybrid chambers, and so on. That, to me, are new impulses in terms of how to deal with criminal prosecution within the existing structures and potentially and preferably with the assistance of the Assembly of State Parties. I don't see how the withdrawal of Burundi or potentially South Africa, we have legislation in Parliament, we don't know where that's going to go, is going to strengthen any regional prosecution mechanism. It would be a devastating signal. And given South Africa's history, it would be terrible for us. And we would be returning to an isolationist policy very, very similar of the one we had during apartheid. We were very open for a short while after 1994. We have become much more inward-looking, unfortunately, like so many other countries. I would see withdrawal as a rejection of very, very basic values in our own constitution. And it's a terrible signal to the victims of these crimes. Mrs. Pillay, you'll have your work cut out for you, I personally think, in linking sanctions and just the threshold issues with crimes against humanity and the causality issues. It's incredibly difficult to actually indicate that specific deaths or deprivations, linking that directly and unequivocally to sanctions is quite a challenge. I'm not sure that is what the ICC should be doing right now, but that's my opinion. Thank you.
Thank you so much, Erica. I would now pass on the floor to David.
Very quickly, Kamari, your comment inspires me to throw out an idea that has emerged in my thinking. We have reached the stage in the United States where the treaty ratification process has come to a grinding halt. The treaty withdrawal process has surged ahead with a speed that we've never seen in our history before, quite frankly. And it does lead me to have the very theoretical hope, and it's only theory, that, quite frankly, maybe we've reached the stage in the United States where if a treaty still requires 2/3 of the Senate for ratification, we should have an amendment to the Constitution that requires 2/3 Senate ratification for withdrawal, because the President's power is being abused. This came up, by the way, many decades ago with respect to our switch of recognition to the People's Republic of China. And I actually sided with Senator Goldwater at the time that President Carter should not be withdrawing from the Mutual Defense Treaty with Taiwan without Senate approval, but we lost in the federal courts on that. Secondly, Ambassador Vedin-Vesar, if it is too difficult a proposition for the ASP, and I can understand why, my alternative to that I've put in my little essay is it could simply be an initiative of the President of the court itself, President Obuchi, or even outside of the formal court structure, interested states who are supportive of the ICC could simply create their own ad hoc select committee and move forward to try to fight the good fight. And finally, Judge Pillay, I'm going to take advantage of your question on China simply because the United States now has a president who is deeply involved in the same argument that China has had for many years, which is non-interference in internal affairs, the preservation of sovereignty, et cetera. So it's a new dialogue in the United States. And I would simply press again that one thing I'd like to see in the United States, if we're going to do it ourselves, is that we adopt a Crimes Against Humanity bill, which we've had floating around since 2010 in the U.S. Senate. And I've been very involved with that, and yet it always has difficulty moving forward.
Thanks so much, David. Dan.
Okay, I would briefly take the two questions relating to China. And first one is about state sovereignty, non-intervention, and human rights issues. I mean, traditional China does have this sensitivity about human rights issues, and it has disengaged itself from any individual petition systems under the UN Treaty body. So it's opt out of all these systems. But gradually, I think China attempts to recognize there is a difference in regarding human rights violation. On one hand, it's kind of ordinary human rights violation that would be subject to multiple human rights conventions. And in this regard, I think the position of China is very strong, and it would against any external intervening in this kind of human rights issues, and it would be considered as domestic affair. But on the other hand, there will be the human rights violation which are so serious that would be amounting to international crime. And I think China has shifted to the position that for international crime that China could accommodate that foreign intervention, but under certain conditions. And actually, China supported the both Security Council resolution in the Libya situation, one imposed a no-fly zone, and the other referred to the ICC. And I think China would put state sovereignty in the first place. And in regarding to the R2P, I think China still considers that states bears the primary responsibility to protect their civilians. So only if they are unable and willing to do so, the international community will be able to intervene. And that's actually it's similar in the context of the ICC. China would be supporting the court in dealing with international crime, but only with the complementarity principle that could be a sufficient mechanism to protect state sovereignty and to make sure that the domestic jurisdiction would actually assume the primary responsibility in prosecuting these crimes. And the second question is actually about the broader engagement of the Chinese students in international criminal practice. I think this kind of activity per se is not indication of the Chinese shift position towards ICC, because there is a broader Chinese strategic plan to engage more broadly or directly with international organizations, including the ICC. And actually, the Chinese government is very active in supporting students in pursuing internships in various international organizations, because it used to be non-funded both domestically and internationally. But now the government is offering very generous financial support to these students who are able and willing to take up internships at various international organizations. But
Dan, sorry, we have to move on.
Yeah, but not exclusively to the ICC. But I would think that this kind of engagement would actually contribute to future direct engagement between China and the ICC, because we actually like expertise and experience in international criminal trial, and because Asia is actually the least representative bloc in the International Criminal Court staff composition, and China has very limited engagement at the professional level with ICC. I think this could be perhaps maybe the ASP could maybe accommodate some kind of applicants or internships or legal officers in the future from non-party states, and that maybe promote increasing interest from non-party states to decide move forward.
Thanks so much, Dan.
Sorry.
I now pass on the floor to Judge Beatty, to Bakia.
Navi, do I have your permission to speak while seated? To sit while speaking? Firstly, in response to the question specifically about Russia, I would say that first scratches appeared with Darfur and specifically al-Bashir arrest warrant, and Russia shared concerns of several African states with respect of immunity of the acting head of state. But also the other issue was striking the right balance between peace and justice. Then Russia voted for the referral of the situation in Libya to the ICC prosecutor, only to soon observe that OTP was taking the approach that Russia read as tilting mostly towards the wrongs committed by the Gaddafi regime rather than wrongs done on civilians by other parties. Likewise, Russia, as you rightly said, cooperated with the OTP with respect to the situation in and around Southeast Asia, only again to observe that what it perceives, and again, I'm giving you the party line the way I read it, only to then observe that most attention was being focused on South Ossetians, their militia, and Russian military who were in the theater, rather than on Georgian side, being rather lenient towards the Georgian side. And finally, Russia certainly found unacceptable approaches taken by the OTP towards the situation in the Ukraine. And again, there was both the treatment of facts and the striking the right balance between the needs of peace and justice. Now, who knows, Professor Zhu, if China, reading between the line what you said, if China decides to join, maybe Russia would follow. Yeah. And then we will get back into this debate. And Hans, thank you for supporting me in this unsigning, rejecting the unsigning concept, because I think that, and Karsten, if you look into Vienna Convention, signature remains there. However, the declaration of intention not to become a party terminates the interim period during which the state makes a pledge not to defeat the purpose and object of the treaty. Now, that does not mean that the state, like Russia, would now blatantly, purposefully defeat the object and purpose of the Rome Statute, but that much depends on the attitude of a particular country. Bill, about Kirill, let's attribute this to an anecdote from diplomatic history. I don't believe that an ambassador to such an important conference would sign or vote for or against a big treaty on his initiative, with all due respect to our common friend Kirill Georgiev. Finally, I should say that there is a continued instruction of future jurists in matters of international criminal justice and international criminal judicial institutions. I mentioned the ICC moot, Russian language ICC moot. Russian teams from Russian universities are not unfamiliar to these premises, and some of them reached quarterfinals, I believe, for class. There is an academic university. We have to finish up. Okay, there is an academic university which trains would-be judges and provides upgrade training to judges in office. They are being made aware of ICC. And finally, I boasted of my contribution to those exchanges between professionals. And I pledge to continue doing this as long as friends and I last. Thank you.
Thank you so much. I think we have 4 takeaway points. First of all, the idea of strengthening the idea of an informal mechanism within the ISP, either on a more formal basis or on the initiative of the president of the court. Secondly, the idea to improve the relationship to non-state parties, partly through domestication and further initiatives to actually implement the statute at the domestic level and to influence decision-making processes. Thirdly, we have a proposal to also engage with the question of silent disengagement with the ICC's agenda. And the fourth issue, which is, I think, also a bridge to the coming panel, is then how to deal with complementarity in a constructive way. Those are, I think, 4 takeaway points from this panel. We've exceeded our time, but I hope you would agree that our panelists did a great job. Thank you.